In real estate transactions, a plaintiff generally can't recover for damages for mental anguish or emotional suffering due to a breach of contract. But what if a defendant knows that his or her breach will reasonably result in mental anguish or emotional suffering? The Alabama Supreme Court considered this question in Sexton v. Clair Federal Savings Bank. In the 1990s, William Jack Sexton and Marsha Sexton received a loan for roughly $160,000 from Clair Federal Savings Bank to construct a home. Under the loan agreement, the bank was to monitor construction and disburse the money through installments or draws based on the stage of construction, also known as a construction loan. Several weeks after construction began, the bank notified the Sextons that the home's construction stage didn't justify the amount of money the builder had drawn. The bank then advised the Sextons that it wouldn't allow more draws. Ultimately, the Sextons couldn't finish construction, and they stopped making payments on the loan. Subsequently, the bank sued the Sextons in state circuit court for breach of contract and sought to foreclose on the property. In response, the Sextons counterclaimed, arguing that the bank breached the loan agreement and its fiduciary duty by failing to appropriately monitor construction and disburse loan proceeds. The Sextons also sought punitive and compensatory damages for their mental anguish and emotional suffering. The bank moved for partial summary judgment on the counterclaims, which the court granted. Specifically, the court found that the Sextons couldn't recover for their mental anguish and emotional suffering because their distress was too remote and wasn't in contemplation of the parties at the time of contracting. The Sextons appealed to the Alabama Supreme Court.